Hyper, we can start recording. Oh. Welcome everybody to Know Your Rights, a guide for LGBTQ2+ employees launch. We're very excited to have you with us today. I am Jade, Pichette, the manager of programs at Pride at Work Canada, and I use the pronouns they and them. Pride at Work Canada, through dialogue, education, and thought leadership, we empower employers to build workplaces that celebrate all employees regardless of gender expression, gender identity, and sexual orientation. We help create safer, more inclusive workplaces that realize the full potential of all employees and bring down barriers to employment. Our learning, networking, and community events happen across the country, celebrating and connecting the most inclusive Canadian employers. We're very proud to say that we recently hit our 200 proud partner mark, as well as we now have over 55 proud community partners as well, which is quite the change from a number of years ago, and it's been quite the growth journey. And we're very excited to have all of you with us, whether you're from a proud partner, a community partner, or just a member of the public joining our event. We'd like to recognize, with all the work that we do, that Pride at Work Canada works on the traditional territories of the First Nations people, Métis Nations, and Inuit. This includes Two-Spirit and LGBTQ Indigenous people, and we recognize that there are multiple barriers that impact Two-Spirit and LGBTQIA+ Indigenous people from accessing meaningful, affirming, and inclusive employment. In our work, we look to reduce those barriers and open to feedback from Indigenous workers, employers, and job seekers in making that a reality. Takaranto, or Toronto, is situated within the lands protected by the Dish with One Spoon Wampum Treaty, which covers the Great Lakes region. Toronto is also covered by Treaty 13, signed with the Mississaugas of Credit, and the Williams Treaties, signed with multiple Mississaugas and Chippewa bands. These lands and waters are the traditional homes and territories of and cared for by the Anishinaabe, Huron-Wendat, Chippewa, Haudenosaunee, and the Mississaugas of the Credit First Nation. Today, Toronto is home to Indigenous, Afro-Indigenous, and urban Indigenous people from across Turtle Island, and I am very grateful personally to live, work, and play on these territories as somebody who is a white settler. If you don't know the traditional territory that you are situated on, we encourage you to check out nativeland.ca. It's not a perfect resource, but it's definitely a helpful one. Our offices are located here in Takaranto, which is why we like to recognize where we are situated. Throughout today's agenda, we encourage you to make use of the captioning that is available at the bottom of your screen. So if you do not know how to get the captioning, go to the bottom of the screen and click either the closed captioning button, which says CC, or show subtitle, depending on your screen. And so these events are captioned by National Captioning Canada, and this event is being recorded and will be available for viewing after the event. We encourage you to use the Q&A function to ask any questions related to the topic of the discussion, but we won't be able to answer every question, but you're welcome to contact us at info@prideatwork.ca after the session. And when it comes to the Q&A, we do encourage you to ask broader questions and not questions that are related to specific cases or legal situations, but broader situations for our panelists. Also, keep the chat an inclusive space. We're all responsible in trying to create that inclusive, accessible, welcoming space. And so very grateful for folks to introduce themselves, say where they're at, and be respectful of people's pronouns, names, and experiences. So throughout the event today, we will talk a little bit about the guide itself, which is now accessible. We'll have remarks by Tabitha Tranquilla of the Canadian Human Rights Commission, and then our fantastic panel of Know Your Rights, a guide for LGBTQ2+ employees, and closing with some resources. I would also like to remind folks that if you are a lawyer in Saskatchewan, Ontario, or New Brunswick, that there are in Saskatchewan and New Brunswick 1.5 continuing professional development hours associated with this event, and 1.5 EDI hours associated with the Law Society of Ontario for this event. So about the guide. This guide was created with the recognition that LGBTQ2+ employees face increased challenges and barriers at work, which are unique to their position as members of two-spirit, queer, trans, gender nonconforming, and other communities. These unique challenges extend to the legal system, in which it has historically been difficult for LGBTQ2+ workers to find justice. This guide aims to provide information that can better prepare LGBTQ2+ employees for navigating the system, as well as for employers themselves. They can look at this guide and make sure that they are doing what they need to do. It includes step-by-step information regarding the process of filing a human rights complaint, which is just one avenue of recourse for being mistreated in the workplace. It also includes summaries of several successful human rights complaint cases, which show the many forms that workplace discrimination can take. As you have registered for this event, you'll get a copy of the resource, as well as it will be available on our website at prideatwork.ca/resources. I also want to give a huge shout out to the author, Meike Jourdain, who is our moderator today, who put so much love and effort into this work. And it was her idea and her effort to put this work together. And so really excited to have her as our moderator today to talk about the guide and talk with some legal experts on the experiences in Canada. So to start our discussion today, I'm very excited to introduce Tabitha Tranquilla, she, her, who's the Acting Director of Policy, Research, and International Affairs at the Canadian Human Rights Commission. She has served as the Commission's primary point of engagement with the United Nations, regional bodies, and the international network of national human rights institutions. Tabitha has spoken at a number of domestic and international events on the role of national human rights institutions in monitoring the domestic implementation of international human rights instruments. LLM in International Human Rights Law from the Irish Centre for Human Rights at the National University of Ireland. And we're very grateful for the amount of support, love, information, and care that the Canadian Human Rights Commission provided in support of this guide. And so welcome, Tabitha.
Thank you so much. It's always an honor for the Canadian Human Rights Commission to be invited to join one of Pride at Work Canada's fantastic events. Before I begin, I would like to acknowledge that the land from which I am speaking today is the traditional and unceded territory of the Algonquin and Anishinaabe Nation, and the land and waters of what is now known as the Ottawa region. And since this is a virtual event, I would like to also join with our hosts in honoring all the various Indigenous territories represented here. And although they are more common these days, I also want to say that these land acknowledgements are much more than a formality. They are an essential part of our dialogue at this event today, and they are an essential part of a larger effort towards reconciliation and understanding of our collective past, present, and future. Today, I have 3 messages for you as Pride at Work launches their publication, Know Your Rights, a guide for LGBTQ2+ employees. My first message is that recovery from this historic pandemic must steer us away from harmful trends and towards greater equality. We all have a part to play in this effort. Second, employers can help meet this challenge by fulfilling their human rights obligations and by going further to be leaders and active agents of change. And finally, for employees to contribute, they must know their rights and how to claim them. And this Pride at Work guide will help with that. So first, I want us all to take a deep breath and take a few minutes to recognize the importance of this time that we are all in together. We are living through some seriously historic moments, and we are at possible turning points in our workplaces and in society. So I want to spend my first few moments reflecting on where we find ourselves presently and explore how we can recover from the pandemic in an inclusive way. So we're still in a pandemic. This, of course, has affected everything: how we live, how we move through our communities, how we work and conduct business, and how we take care of our own health and the health of our families, including our chosen families. It has affected how we show love and affection to those most dear to us, how we protect one another's well-being as friends and as strangers, and how we say goodbye to those who we have lost. The pandemic has affected some more than others. 2S LGBTQI communities have been both hard hit and uniquely impacted. The pandemic has both deepened and made visible many systemic inequalities. As we recover, it is important that we do not carry these inequalities with us. It is critical that no one be left behind. The pandemic has also starkly revealed how connected we all are. Our health and humanity are intertwined, and this recognition of shared connection and humanity is fundamental to human rights. In that spirit of shared connection, growing awareness of and commitment to the goal of reconciliation with Indigenous peoples is a touch point and a source of hope. We've seen increased public recognition of the calls to action of the Truth and Reconciliation Commission, with Two-Spirit and LGBTQI Indigenous voices urging greater recognition and respect. The Canadian Human Rights Commission encourages all non-Indigenous workplace leaders and employees in Canada to take an active role in this work of reconciliation. Set aside time for your employees. Build it into your accountability frameworks and your performance objectives. Host events and set concrete goals to learn more about the truth of our collective history and the importance of dismantling the decades of systemic racism, colonialism, and erasure that Indigenous peoples have endured. If we do this, we can take mindful steps towards reconciliation as we gradually move out of the pandemic and walk together as thriving communities towards a better future. While this is a hopeful message, however, we must also be mindful of concerning trends we are seeing in Canada and elsewhere as we continue to weather the storm and slowly move towards recovery. A continued rise in hate, intolerance, threats, and violence is threatening many groups, including Indigenous, Black, Asian, Muslim, Jewish, and 2S LGBTQI communities, both online and off. This hate can also seek to divide equality-seeking groups, even as we strive for progress together, and it can destabilize our democracy. Increasing societal awareness of systemic racism and transphobia and action to counteract these things has been slow. We know that this affects individual health, safety, and well-being, especially for those who face intersectional discrimination on multiple fronts. None of this was helped by the pandemic. In fact, those individuals and groups who have historically borne the brunt of discrimination in our society have borne the brunt of this historic crisis even more so. The fact is, no one in Canada should feel threatened or afraid because of who they are, how they express themselves, or whom they love. Not during a pandemic, not after, and certainly not at work. Simply put, hate must not be part of our new normal. So we know that the status quo just isn't good enough. We know that we can and must do better. We've all likely heard the catchphrase, building back better. But what does it mean? For us at the Commission, building back better starts with ensuring that everyone feels safe, welcomed, and included. It also means that we should strive to build back our economy, our workplaces, and our daily lives differently, with more empathy and with greater respect for human rights and inclusion. We need to build back with a greater sense of our common humanity and with a greater awareness of our individual privileges. Our recovery from the pandemic must steer us away from harmful trends and towards greater equality. This now can be our turning point in society and in all our workplaces. But we must all play a part in this endeavor, including both employers and employees. So now that we're done reflecting, I'll make my last 2 points a little bit quicker. My second message for you today is that employers can help meet the challenges we face today by fulfilling their human rights obligations and responsibilities, and by striving to be leaders and active agents of change. We know many businesses and organizations are still struggling as Canada continues to adapt to the new realities created by the pandemic. To ensure we leave no one behind, employers must make sure that they meet existing human rights standards, including those written in our various provincial and territorial human rights codes and the federal human rights statute, the Canadian Human Rights Act. That goes without saying. However, to be a successful Canadian business in this new era means not only being a leader in your specific field and following the law, but also being a leader in anti-racism, diversity, equity, and inclusion. At the CHRC, we think that this leadership means integrating 5 principles for workplace transformation: truth and reconciliation learning and practices, anti-racism values and practices, accessible services and business, gender equality for all genders, along with pay equity, and the UN guiding principles on business and human rights, along with the UN LGBTQ2I standards of conduct. We think that integration of these 5 principles is good, not just for human rights, and it's not just the right thing to do. It's the smart thing to do from a business perspective, because consumers are drawn to companies that embrace diversity and inclusion, and that in turn attracts top employees. We urge employers to build these principles into concrete actions, into your plans and policies, and to build your own workplaces back better. And with that, I've come to my final message, which is this. In order for employees to contribute to the advancement of human rights, they must know their rights and be empowered and supported to claim them. And this Pride at Work publication, Know Your Rights, a guide for LGBTQ2+ employees, is a great step in that direction. With a combination of practical information and actual case studies, the guide offers up-to-date guidance. Employees don't have to feel alone, and now they'll have a place to start, a framework from which they can begin the conversations, those vital, albeit uncomfortable, conversations that must take place in order for change to happen. We were so pleased to assist in the development of this publication, and we congratulate Meike, Jade, and everyone at Pride at Work. In closing, I want to thank Pride at Work Canada for all that you are doing to help assist employers and employees to advance human rights and to help lift up Canada's next generation of 2S LGBTQI leaders in businesses and workplaces across Canada and the world. Canada needs you all. When you thrive, Canada thrives. Thank you for your time, and I'll turn it back over to Jade.
Thank you so much, Tabitha. That was absolutely fantastic. And I really appreciate how you connect the importance of intersectionality in the work, and that although we are focused on sexual orientation, gender identity, and gender expression in this guide, addressing multiple grounds of discrimination is often what happens. And so we're so grateful for the support of the Canadian Human Rights Commission in the creation and promotion of this guide. And thank you so much for being with us today. So now we get to move into our panel. And I would like to start by introducing Meike Jourdain, who is our Programming and Engagement Coordinator at Pride at Work Canada. She joined our team back in January, originally as a programs assistant, and started this as her independent project. This was the thing that she wanted to work on, as the law and experiences with discrimination within the law is an area of serious interest and passion for her. We've been really happy to have her join as the Programming Engagement Coordinator since then, in a permanent full-time position where she manages our Community Partnership Program, working with over 55 different community organizations across the country, as well as our Ambassador Program, which engages our proud partners in multiple regions across the country. She has over 3 years of experience as an educator of 2S LGBTQIA+ issues, and she compiled this information for this resource with assistance and feedback from the Canadian Human Rights Commission and the Community Justice Collective, who we also want to thank. So welcome, Meike, and congratulations on the publication of this guide.
Thanks so much for the introduction, Jade, and for those wonderful remarks, Tabitha. We're so happy that the Canadian Human Rights Commission could be featured today as a testament to all of the support and assistance that they provided to me in creating this guide. I also wanted to take a moment here just to acknowledge that I'm also in Toronto. And yeah, just take a minute to, in the spirit of, recognizing land acknowledgements as a call to action as much as an acknowledgement. I'd just like to encourage the settler folks who have joined the call today to try and familiarize yourself with any land back or land defense movements that are happening near you or in the colonial boundaries of your province. I know for me in Toronto, that means learning about what's going on right now at 1492 Land Back Lane, where Haudenosaunee land defenders are currently fighting for their rights to land that they were guaranteed through the Haldimand Tract Treaty, which is a treaty that covers territories on some sections of either side of the Grand River. So I've just posted the website just now in the chat for you to go check out. If you're also in Toronto, they have ways that you can support there, either by financially or other forms of donation. So yeah, just encourage you to check that out and make yourself familiar with what's going on near you. It's a great way to be able to support Indigenous sovereignty and self-determination. So with that said, I'm really happy to introduce our panelists today. We have a great group of speakers, which is really exciting. They're going to offer some excellent perspectives. So Jade, if you just want to turn to the next slide here, I'll start with Lorenzo Lisi first. Him. Lorenzo is a partner and practice group leader for the workplace law group at Berlis law firm. Lorenzo has practiced and presented on labor and employment law for over 30 years, so he's certainly qualified to be on this panel today. His clients include both provincially and federally regulated workplaces. Lorenzo advises employers on all labor and employment matters, including attracting and retaining talent, fostering inclusion, and promoting equity for LGBTQ2+ community members through training and proactive advice to employers, as well as for other historically underrepresented groups. Lorenzo has also served on the board of directors of the Canadian Association of Counsel to Employers, as well as the Government Affairs Committee of the Human Resources Professionals Association of Ontario. So thank you so much, Lorenzo, for being here, and we'll hear from you in a little bit.
Thank you.
So next up, we also have Laleh Moshiri, pronouns are she, her. Laleh is the National Director of Diversity and Inclusion for Borden, Ladner, and Gervais, the law firm, which is also a proud partner of ours, as is Berlis. Laleh is, as I said, the National Director of Diversity and Inclusion, and in this capacity, she's responsible for developing and implementing the firm's diversity and inclusion strategy. Under her leadership, BLG was recognized as one of Canada's top 100 diversity employers, and Laleh herself has received the Canadian Centre for Diversity and Inclusion's Practitioner of the Year Award in 2017. Laleh received her BA in history from Williams College and her law degree from the University of Toronto. She was called to the Ontario Bar in 1994 and began her legal career at BLG as a litigator specializing in health law initially. She transitioned to law firm administration in 1998 and has over 20 years of progressive responsibility and experience in managing professional talent at BLG. So Laleh, thanks so much for being here. We're really excited to hear from you in a little bit. And finally, we have El-Farouk Khaki, pronouns are he, him. El-Farouk is an intersectional human rights and dignity activist, public speaker, writer, author, media commentator on issues such as Islam, LGBTIQ and human rights, refugees, politics, racism, HIV, and queer parenting. El-Farouk is also a lawyer who's practiced since 1993, focuses on refugee claims based on sexual orientation, gender, gender identity, expression, and HIV. He's also the co-owner of the Glad Day Bookshop, which is the world's oldest LGBTIQ bookshop. And he's also the founder of Salam Queer Muslim Community, as well as the co-founder and imam of El-Tawhid Juma Circle, or the Unity Mosque. He is ordained as a reverend and officiates marriages for all orientations and genders. He's also been featured in a biopic titled The Accidental Activist by the Canadian Race Relations Foundation, and is a TEDx speaker. We've included the links to some of those YouTube videos towards the end of the presentation. And El-Farouk has also received awards such as the Excellence in Spirituality Award from Pride Toronto in 2006, as well as the Community One Steinart and Ferrero Award. In 2020, he was inducted into the Archives National Portrait Collection. And his writings include a children's book titled Moondragon in the Moss Garden, co-authored with Troy Jackson, as well as a chapter on Muslim chaplaincy and LGBTIQ plus Muslims in Mantle of Mercy, Islamic chaplaincy in North America. And currently, El-Farouk is working on a book exploring Islam, intersectional identities, global issues, sexuality, refugees, social justice, and spirituality. So yeah, with that said, we're really excited to kind of get into our discussion now. I'll ask all of our panelists just to turn your camera on, and we'll start our discussion off with a general question that I'd like each of you to answer. Just starting off with an obvious statement here for the beginning of our discussion. Coming forward with a complaint about discrimination in the workplace is not easy. In reviewing cases and doing the research for this guide, we found that when 2S LGBTQIA+ workers did come forward, they often faced a manager or a supervisor that minimized their experience by suggesting that the discrimination was the result of an interpersonal issue. So the person making the complaint might hear something like, so-and-so makes jokes like that sometimes, or we can change your shifts so that you don't have to deal with that person. From your perspective, and we'll start with Lorenzo here, why is it important to consider discrimination in the workplace a structural rather than an interpersonal issue between two people?
Thank you very much, and thank you for having me today. I think, and I'll put my my background straight up front here. I represent employers, so I am a management side lawyer for employers, generally in the province of Ontario. And so part of the issue here, and part of the reasons why I'm so happy to be talking, is that I think it creates a larger discussion about what's good for the individual, and which in turn is what's good for, and to echo some of Tabitha's earlier comments. So I think we should also broaden the discussion, not only to just prohibited grounds of discrimination, but also harassment and bullying in the workplace, which is also an occupational health and safety matter, and triggers the right for investigations and complaints independently, both federally and in various provincial and territorial jurisdictions across Canada. So I think that the straight answer to your question is that it is a complex issue in workplaces, because whether it's unionized or non-unionized, employers are often kind of relegate the issue of interpersonal relationships and then discrimination, which may arise in the workplace, to a kind of lower level due to, particularly during the pandemic and coming out of the pandemic, concerns about the business, the busyness, how they can deal with it, lack of resources. So you throw that all into a pot and you start to get a situation where it is relegated to an interpersonal situation. And the solution, the easy solution, is often, we'll move you away. You don't have to deal with that individual. I hope that solves the problem. So part of this is part of the function and the pathology of the workplace in many ways, if I can put it that way. And part of it is the fact that I think we are still evolving from a workplace perspective in terms of recognizing not only the manner in which to deal with it, because quite frankly, and I've done this for the last 20 years, we've been doing training on workplace policies and complaint procedures, and they are in place. Most employers have them in place. So those exist. It's not only the issue of having the policy, it's making it a kind of living document where managers, supervisors, unions understand what the issues are, and they're dealt with from a more kind of holistic, systemic perspective rather than a one-off. Now, I'm not going to lie, most employers have to deal with them from a one-off perspective because they're complaint generated. And that is part of the issue which we are dealing with in workplaces now, which is constructive knowledge of situations and what you're supposed to do when you have constructive knowledge, which also initiates a process. So the answer is, it's not such a simple question, but it's also a matter of putting the right policies and procedures in place, doing the right amount of education, and not leaving it to just being complaint driven, and understanding that where there is information that is available to an employer, then it needs to be acted on. I think that's probably the best way I can put it.
Yeah, I think that's an excellent way to put it, and kind of brings up something that we'll talk about a little further on in our discussion, which is how employers can be more proactive when it comes to creating that living document, like you were mentioning, and making sure that those policies and procedures are in place prior to a complaint arising. Next, we'll turn to El-Farouk. So for you, from your perspective, why is it important to consider discrimination in the workplace a structural rather than an interpersonal issue?
Well, so I work for myself, but assuming in a larger workforce. Hello, everybody. My name is El-Farouk. I go by he, him pronouns, and I'm in Toronto in the traditional territories of the Mississaugas of the New Credit. I was listening to you, Lorenzo, from the employer side. I think it makes good business sense to have a healthy employee force, and good health includes mental health. And I have been in toxic work environments where I just don't want to go to work. It's easier now, I guess, on some level if you're working remotely online, but I think when you have a toxic work environment, it affects the individual worker and affects productivity of that individual and the people around them. So it makes good business sense for the employer. The other issue is that many people, even if they're aware that what is happening to them is a violation of their rights, do not have the courage or the opportunities or enough information to be able to bring those complaints forward. And then there's always the fear of the aftermath. What happens after all of this, and where do I end up? And so that is why it's extremely important for it to be a structural response, as opposed to an individual response. Because if it's an individual response, it's a response that's going to have to be repeated over and over again, because you're not actually solving the problem. And the problem will persist unless it's addressed as a structural issue. I think part of the narrative of shifting the structural issue is to talk about how individuals are impacted. What does that discrimination actually look like? What constitutes discrimination? What kind of treatment? So living examples of that, I think, become very important for employers to understand how these how discrimination or othering can happen in a workplace and how it impacts on people. And we can't expect that those who are wounded are going to be the ones who are always going to have to step forward to say, this is how I'm wounded, and then having to prove it. I think there's an onus on the employer. And like I said, I think that onus makes good business sense.
Thanks, El-Farouk. Yeah, 100% echo your comments regarding just the burden and the courage that it takes to come forward as someone that's been wounded, to try and advocate for yourself, and how that's an essential piece of understanding workplace discrimination as a structural issue. So to turn it over to you, Laleh, what's your perspective on this topic of considering discrimination at work a structural rather than an interpersonal issue?
Thanks, Meike. I want to say first that I certainly support and echo what has already been said on this topic, and I'll approach it maybe in a complementary but slightly different way. The question actually makes me think of literature that I've read about the effectiveness of unconscious bias training, and the question being, do you take the bias out of the system, or do you take the bias out of individuals? And I actually think you need to do both. So you absolutely have to address the structural issues. You absolutely, as Lorenzo says, have to have all the policies, the anti-discrimination harassment policies in place, and you know, that's all table stakes. I mean, we all have those policies in place right now. But here's the thing: you can have all the policies in the world in place, but you need people to buy in and to act if you want to actually change the culture of an organization. And of course, leadership plays an important role in that. You need leadership who will really walk the talk. Their words matter, their actions matter. You need that tone from the top. And they make it clear, you know, that there are certain behaviors and comments that are simply not acceptable in your workplace. So, for example, you know, jokes that you mentioned in your question, so-called jokes, or just and microaggressions, which actually are not really micro because they have a huge impact. If those seemingly small things aren't addressed, they then are normalized and become part of the culture. So again, address the structural issues, but create a safe and inclusive environment where there is buy-in from all. And I can tell you that one of the ways we do that is through continuous training and education. And it's not just sort of training and education that is driven by legislation, but it's training and education that I think increases people's awareness, increases people's empathy, and you also want people to be given tools to turn that empathy into action. And just as a very recent example of something that we did just last week, we had arranged a firm-wide training session on bystander intervention. And so again, with that, it was an opportunity to give people practical tips on how to turn that empathy into action and ensure that creating an inclusive workplace is everybody's responsibility.
Thank you, Laleh. I think that kind of nicely ties up that question. So I really appreciate all of your contributions. For our next question, we'll turn to El-Farouk again. So when we are creating this guide, a central piece of it for us was making sure that we communicated the message that experiences of discrimination are shaped by the specific ways that an individual's identities intersect and overlap with one another. We stress that because of this reality, discrimination can come in many, many different forms, that all experiences are valid, and that you can make a human rights complaint on the basis of multiple protected grounds. So as a human rights activist and as a lawyer, can you first kind of briefly explain for our audience what I mean when I say multiple protected grounds, and then speak to why it's necessary to affirm that experiences of discrimination can take many of these forms and are often compounded for folks with intersecting identities?
Certainly. I deal with this often in the context of my law practice. I representing refugees, many of whom are racialized, many of whom are women, some of whom are HIV positive, they're newcomers. Language might be an issue. Education equivalency might be a challenge. So I speak of multiple protected grounds or intersectionality as layers of a lasagna. I saw a meme on Instagram the other day of somebody who was sort of claiming their identities and said, I am layers, not fractions. And I think a lot of people are layers. We have multiple identities. And sometimes when we're facing discrimination, also, it's really hard to say why you are being discriminated. Is it because of your skin color? Is it because of your religion or your gender expression? how do you quantify and how do you break that down? And I don't think you have to. I think when we talk about these multiple protected grounds, is a recognition that these are also working in tandem with each other, and that depending on your intersectionalities, then you might be facing multiple disadvantages and multiple sources or compounding sources of discrimination. So being queer and being racialized and speaking English with an accent, or coming from a country outside of North America are those kinds of different grounds and the protected grounds that can affect an individual. And again, very difficult to separate and say I'm facing this because of this issue as opposed to that issue. And this allows us to not have to choose those our different layers over another.
That's great. Thank you so much for that answer. I love the piece about the human lasagna and being layers, not fractions. That's great. And yeah, something that we really noticed when just looking at cases and doing the research for this guide is that folks have a really hard time articulating, you know, how discrimination is connected to their different identities. And the reason is often that it's because it's all muddled together and so complexly intertwined that it is just a matter of all of those things kind of happening at once and being difficult to kind of separate and discern from one another. So it was really important that we kind of affirm that for people in this guide and make sure that they understand that that's totally reasonable and a very common experience.
Yeah, if I can add to that, I think one
Sure.
of the challenges are for many folks is about the accessibility of information and even understanding that what they're being subject to is treatment that is not acceptable and actually not legal. And that's also part of the challenge for many newcomers, because they come from a particular context where those issues are even more difficult than they might be in Canada. So that education piece, I think, is also very important.
Yeah, that's a great addition. Thank you. So next, I have a question for Laleh again. So when we are creating this guide, we created it with the knowledge that all too often the burden falls on workers to point out discrimination in the workplace and advocate for themselves, which goes back to what Lorenzo was saying earlier about this kind of being a complaints-driven process rather than a preemptive one. So as the person leading the development and implementation of BLG's diversity and inclusion strategy, what does it mean to you to create an affirming environment where employees can feel comfortable coming forward with experiences of workplace discrimination?
Thanks, Meike. This is such an important question because, as I mentioned earlier, you can have all the policies in the world, but if you haven't created an inclusive culture, it won't matter. So you first want to create a culture where people can be themselves and then empower them to come forward should there be instances of harassment and discrimination. And I'll say the number one thing from an employer perspective is to do the work. You don't create an inclusive culture by putting up rainbow flags during Pride every year. And while overall inclusion efforts are important, you also have to work at creating an inclusive culture that actually explicitly promotes awareness around LGBTQ+ issues. So let me give you an example of one of the ways that we have tried to build an inclusive culture at BLG that hopefully empowers our people. In 2016, we rolled out a trans accommodation and inclusivity policy. And the purpose of the policy really was to provide guidance on supporting, respecting, and accommodating trans individuals and preventing harassment and discrimination on the basis of gender identity and gender expression. The policy was accompanied by a number of initiatives. So we made changes to many of our existing policies. We specifically identified gender identity and gender expression in our harassment policy. We created all gender washrooms. We removed gendered references in our dress policies. We reviewed all of our policies to remove gendered pronouns. So all the he, she's were removed and replaced with they. And it's interesting because my guess is that 40 years ago, someone was being progressive and they went in and replaced all the he's with the he/she's. But of course, we've now changed that. And of course, training. We did training that was specifically targeted to HR and our people managers. We did training for the entire firm, which included hearing from trans voices, including trans voices, and really creating awareness around different lived experiences. 1 year after we rolled out this policy and we did all the work, we actually had our first firm member come forward to tell us that he was transitioning. And he specifically mentioned that the work we had done was one of the reasons he felt comfortable coming forward at the time that he did. And he felt comfortable, being his true self in the workplace. Now, he also chose to come out in a very public way. It was part of our transition support plan is to really rely on the individual undergoing the transition to direct the process. Every transition is going to be different, and it is very much directed by the individual. And so he chose to come out in a very public way by sharing his story with the entire firm of 2,000 people. And I can tell you that he was, people at the firm literally and figuratively wrapped their arms around him. And for him, it was such an affirming experience. Now, not everybody's going to choose to do that, but the fact that he did was, I think, quite significant from us, particularly since it was the very first gender transition that we had supported in our workplace. So we rolled out this policy 5 years ago, but the work didn't stop there. A couple of years ago, we introduced we sent around an email encouraging people to add their pronouns to their email signatures. We didn't mandate it, but we explained the thinking behind it and why it was important for people to do that. And we certainly aren't tracking the numbers, but I do have a sense that a great many people at our firm are including their pronouns. And finally, we recently introduced gender affirmation coverage through our extended healthcare benefits. So again, really supporting our individuals to be themselves and to, in communicating that to our entire firm, helping in terms of creating that inclusive workplace.
Thanks, Laleh. I think those are some really great kind of concrete examples that'll hopefully resonate for folks. There's one thing that you said that I really want to zero in on, which is kind of when you were talking about changing the language from he/she to they, and how, at one point it might have been progressive for the employer to include the she. And I think that's really interesting because it speaks to how this is such an evolving issue. And therefore, it's absolutely essential that employers try their best to stay ahead of the curve in that regard, because it is something that is constantly evolving. Which brings me to my next question for Lorenzo. So a section of this guide is titled, "What is my employer responsible for?" And it provides some information about an employer's duty to accommodate. Given your extensive experience advising employers on how to create workplaces that are inclusive of 2S LGBTQIA+ employees, Can you briefly describe the duty to accommodate for our audience and speak to what a proactive employer looks like?
Great, thank you. So I'm not going to give you the so much legal definition, because that's about as exciting as what as watching paint dry. And I know you want the lawyer to do that, but I think I'll put it really simply. You can't discriminate on prohibited grounds of discrimination. That's both a procedural and a substantive obligation on employers. By procedural, it means the law has interpreted that to mean you have to take all the steps procedurally to find out if an accommodation is possible, and that substantively implement those processes. And you have to do so to the point of undue hardship, which, as anybody who's practiced in this area will know, is a very, very high standard. Now, there's a couple things I want to be very clear about here. The standard of undue hardship is very much impacted by the duty of safety in the workplace, for example. So the duty to accommodate can be impacted by safety considerations. And secondly, that the obligation to accommodate, while it intersects, it doesn't protect legitimate work performance issues. And that is one of the big things that I find I need to explain to employers, because that dissection and how to separate them is very, very important. Because I often find that where there are issues with respect to discrimination, they are associated with work performance issues, and it's either one or the other. Either the work performance may have triggered something which led to a complaint, or the complaint has led to work performance issues. And unpacking that and figuring it out is part of the job for lawyers and investigators, but also really for me is an unnecessary waste of time and energy in many cases, because the horse is already out of the barn by that time, right? So the duty to accommodate is a legal concept, which, and you talked earlier about the evolution. Well, I will tell you, law lags behind society in many times. We're waiting for decisions, and we're waiting for guidance from employers and legislation. It's a very slow moving machine, right? So the way to get ahead of that and get in front of it is, and I echo both El-Farouk's and Laleh's comments, it's a training issue, but it's not just training, because anybody can be trained. You can sign off that you're there. It's an understanding and a perception issue. I can't tell you the number of times where I've gone to employers and they've done something which they thought was good and positive and inclusive, but it actually, in some ways, to some groups, was offensive or inappropriate. And that wasn't, I'm not going to use the word ignorance, but it was in many cases because a lack of understanding. And that is part of effectively what I see one of the big issues is getting that information to a point where it's triggered in the workplace, effective, and understood. And those are three different processes. The duty to accommodate is a legal principle that judges and arbitrators and tribunals look at to determine if there's legal liability arising from an action in the workplace. That doesn't help people on a day-to-day basis because it's a big concept. What does help people on a day-to-day basis to understand that it is a reasonable standard and it is protection under the law, and there's an obligation on employers. How do we then work all that together? It's kind of like it's a Lego set, you can build it different ways. It doesn't have to look, the same pieces can look like a different structure. And employers need to be encouraged to understand not only the obligation to accommodate, and by the way, I think 99% of the employers I deal with are good employers, and they mean well, and they have the policies and procedures in place. Whether that always means that they do the right thing, right, doesn't necessarily mean they deserve legal liability. It means they need to understand the next step of what the process looks like. And that might include, I heard, the concept of bystander intervention. One of the big problems, and I'll talk about this a little bit later in the next question, but one of the big problems that I see is that when we get a complaint in a workforce, it blows up the workforce. You get sides, you get support, you have to and against. And then after the complaint is resolved or a decision is made on the complaint, everything's just left alone. And the workplace has to reintegrate where you've had these two sides kind of battling. And that really is effectively a problem that I see from a structural perspective on the duty to accommodate. We can do the legal stuff, but then what surrounds that, right? How do you fix the broken machine? How do you make sure it doesn't break again? right? And that doesn't mean that all employers, and that's one thing I really do want to stress. Most employers are looking at, they're busy, they're looking at legitimate work performance issues. They don't do the triage when something comes in or when information comes in. You know, one of the things when the bullying and harassment intervention legislation came out a number of years ago, I started to say to employers, take a look at your attendance and absenteeism. If you start to see that people in certain sectors where there might be issues in that area, or there might be domestic abuse at home, where attendance starts to spike, where people who are normally good employees start to stay at home or start to fight with other employees or start to fight with management, that is a red flag that you may need to look into something. That's a constructive knowledge issue. So the duty to accommodate as a legal principle is easy in many ways, although we've been litigating it for about 50 years right now, but the application is more difficult. And that applies to both unionized and non-unionized workplaces. In some ways, even more difficult in unionized workplaces because we're doing it as a tripartite system. So that's kind of a long way of saying that the law exists the way it exists, but the application of the law really does take into account all of the things that we're talking about today.
Thanks, Lorenzo. That's yeah, an excellent answer to that question, and I think provides a lot of concrete examples, as well as sort of kind of the more abstract systems that govern the duty to accommodate. Just before I get into some of the Q&A questions that we have, and I encourage attendees to keep sending them in, I want to go back to El-Farouk once again, just to ask, your career has been dedicated to helping people advocate for themselves and navigate complex administrative systems. So with that experience and knowledge, can you tell us why it's essential that people have the tools that they need to understand what their rights are? Kind of going back to that education piece you were touching on earlier.
I think a lot of people that I encounter, and these are not universal, just my experience in the populations that I deal with, being many newcomer and immigrant communities, people don't actually know what their legal rights are. They don't know the mechanisms that are available to them. My husband often tells this story about when he was working at a restaurant in Vancouver and talking to some of the kitchen staff who were all racialized immigrant women. And he said something about holiday pay, and they went, "What's that?" Because they had never received their holiday pay. They didn't even know that there was such a thing, right? Well, they did get their holiday pay and then some eventually, but a lot of folks just don't know what their rights are. A lot of newcomer and immigrant folks also may end up working with people from their own community, not getting exposed to the larger community and getting access to information about what is possible here in terms of their rights and what actually even just constitutes that. So, you know, when you and I were talking earlier, Meike, I suggested checklists and stuff, and I would even say it needs to be in a multiplicity of languages, even for queer folk, because queer folk don't just speak English, and some don't speak any English at all, right? So that would be part of my suggestion with that, because and some very simple and digestible information, because people I think the average person kind of freaks out about legal stuff. They don't know how to even ingest it, let alone digest it. So me and my food analogies, but they tend to work for some people. But I think it's really important for that to happen. So.
Yeah, that's an excellent point. That's something that in writing the guide, it was a very hard, balance to strike in terms of providing people with the information and making sure that, if they saw legal terminology, they might be able to understand it. But then also ensuring that the information was easy to read, easy to understand, not too overwhelming. And that's a very difficult tension to work around. So I hope that we've done that in the guide by including things like a glossary as well as step-by-step information for how to file a complaint. But of course, there are many other ways to advocate for yourself. And if we were to cover every single one, we'd end up, with a document that was well over 100 pages. So yeah, I really appreciate you mentioning that point. Did you have something to add?
No, I always come back to the issue of narrative and sharing, and actually sharing concrete people's experience. So when Laleh was talking and gave a specific example of how that policy manifested and the change that sort of brought about, concrete stuff, concrete stories of people's experiences and the resolution of those experiences, I think becomes a way that a lot of people can access the system because they can see themselves in it. Most people see themselves outside of the legal system, I think.
Right. Well, then in that case, I'll note that there are several case examples listed in the document. But I also maybe kind of going back to that concrete piece, and I think Lorenzo and Laleh, you might have some answers to this question that we've received through the Q&A, which is about how to be more effective in terms of training and education, and avoiding taking a negative approach of telling people that they're doing the wrong thing, and instead trying to create a common vision, or as Laleh pointed out, a workplace culture that's affirming, as opposed to kind of just meeting the lowest common legislative denominator. So Lorenzo, if you want to tackle that one first, you're welcome.
Sure. So I'm going to echo, some of what Laleh said earlier on, which I think experiences amongst bringing people together are usually one of the better ways to do that, at least from a larger organizational perspective, because you're often in silos where you don't deal with each other on a regular. I know in law firms we are for sure, where you need to kind of get people out to say, I use the example with my clients and a lot of my colleagues here and my partners that, if you've ever gone to a really good cross-cultural wedding, right, where people that you're not familiar with, and all of a sudden you see them at their best, right? And how when you walk out of that, you change the way that you look at people, because you say, gee, they're like me, they're having a good time, they're having, they're dancing, they're having fun, they're laughing, they're together. And those examples of getting people together is probably the best way that I've seen employers kind of take the kind of dry, staid policy and put it into place to say that now we're actually starting to associate people together, because that makes it easier for people, number one, to come forward, and number two, for people to understand that people may want to come forward. And the other thing that I might emphasize on that point is I really do encourage both employers and individuals who may seek to use the system and to make a complaint. I think that policies do have those procedures that say, let's try to deal with this first, for a reason. And that is because a lot of the stuff can oftentimes be dealt with early on from a kind of preventative perspective, not necessarily just an interpersonal decision, but from a preventative perspective. And I really encourage that early intervention process for employers, because I think it makes a lot of sense. It's a good business decision, but it also makes people less afraid to come forward if that's taken into consideration right away. And that's really, so I think, if you can use real stories and get people to share those stories and then use them as part of your training, doing the dry training and the dry policy stuff, that leaves people pretty quickly. The other part doesn't. And when I do training like Zoom training or harassment and discrimination training, I tend to try to use examples that are not case-based, that are case-based, but not reading a case, right? Because then it puts them into their own mind as to what it could be. And you say to them, how would you like your significant other, your son, your mother, your father, your daughter, how would you like them to be treated in the workplace? Because that's the standard that we're trying to go to. And then you take it from there. That resonates, personal experience resonates. And that's why I think, El-Farouk, I agree with what you've said as well about that, because it really does make a difference.
Yeah, it's true. The personal experience certainly carries more resonance for people, but it's also a tricky balance of recognizing that in the workplace, members of the 2S LGBTQIA+ community and members of other kind of underrepresented communities are consistently asked to do that work of sharing personal experiences as a form of education. And so it's it's a difficult balance to hold, recognizing that that is a problem and that is an issue, but that the sharing of personal experience is something that is, very effective in terms of making people feel a sense of community with others who are different than them. So I think that, a good kind of education and training would take that into consideration and recognize that if people are going to be doing that work of sharing their personal experiences, they should be, paid well, treated well, voluntarily doing so. And I think that's an excellent point to communicate.
I would say that just even a step back without even requiring people to share their personal experiences, because that can also be kind of, there's a lot of pressure on people to do that. I agree. But I think just the initial point of getting people together from different groups that actually can start to associate. I think the pandemic has been terrible for that. And I think it's really hurt a lot of workplaces, I got to say, both from a mental health perspective and a community perspective, but just events where people get together, right, makes a difference. It starts to lower it starts to kind of melt the boundaries away and do so in a kind of an inclusive environment where you take those things into consideration. But I agree with what you said.
Mm-hmm. El-Farouk, go ahead.
Yeah, I understand the emotional labor in terms of sharing stories and again triggering the already injured. But I'm also thinking of composite stories, and I often give this example, which is the campaign for equal families here in Ontario back in the 1990s, and that was the effort to equalize same-sex common law relationships with heterosexual common law relationships. And the majority of people in Ontario were actually against this omnibus piece of legislation until they started to hear the stories of how families and individuals and their neighbors and their friends and their co-workers were actually injured. And so the conversation is a little bit beyond rights and about actually dignity. And Lorenzo, how would you want your child, your parent, your sibling to be treated, right? It comes down to that. And so people started to see how these, the exclusion of these kinds of protections and coverages for same-sex couples was how injurious it was and what kind of an affront to their dignity it could cause. That's when hearts started to change and then minds started to change. And so that's where I think the importance comes in, recognizing the emotional labor of people to share their stories. But maybe sometimes the stories can be composite stories of experiences rather than individuals coming forward with their own stories.
Mm-hmm. So I agree with what has been said so far. Just a couple of things on that sort of emotional labor and that emotional burden. I think you do have to be very careful about that in the workplace because people have their day job, and if you're constantly putting the burden on them to educate everybody else, that's problematic. And so so one of the ways you deal with that is to bring in people from the outside who can share their lived experiences. And I think to Lorenzo's point, I mean, one of the best ways of countering bias is to really get to know people who are different from you. And so hearing those stories is so important, which again is one of the things that we've done. We've really stayed away from that training, that sort of didactic, here's what you must do, here's what the law says, but it's more, as I said before, about increasing people's empathy. So, sorry, that's it.
That's excellent. Thanks for that contribution, Laleh. I wanted to highlight something that I'm seeing in both the chat as well as in the Q&A box, which is kind kind of these issues around transparency on the side of the employer in terms of actions that they're taking to prevent discrimination in the workplace. Folks are kind of sharing their experiences with, employers conducting investigations into discrimination in the workplace and then not releasing the findings, for example. So maybe this is more of a question for Lorenzo and Laleh around just some of those issues around transparency and also, other kind of pitfalls that employers might make in their approaches to trying to create workplaces that are affirming.
Laleh, do you want to go ahead or do you want me to grab that first?
I'd like you to go ahead.
Okay. I probably have a lot of experience in this.
Exactly.
So look, investigations are difficult, as I said earlier on, because you often have those kind of the two sides that develop with respect to investigations and complaints, and they're often very public and they're known because, as you know, it's really hard to keep the subject matter of an investigation quiet, because confidentiality is impossible when you have to let people know what the allegations are. It's one of the issues about bringing people forward is that they're afraid that it's going to get out in the workplace if they don't want it to get out in the workplace. So one of the biggest mistakes I always see is what I referred to earlier on, which is you don't deal with the aftermath. And the aftermath is a huge issue because people are divided, and I think you need to figure out a way how to move forward. But in terms of transparency during the currency of the investigation, it's a fine line to walk for employers, because on the one hand, they are trying to the extent possible to maintain the confidentiality. They understand that some information is going to get out there and people are going to talk, but they don't want everybody to know what's going on. But the results of the finding are also oftentimes, are brought together, are condensed in information, and then given to both the complainant and to the alleged either discriminator or harasser. So what employers don't do in that case is they don't then deal with the workplace and the impact of that. Right now, again, sometimes they're worried for morale issues to go out and say, gee, sending a memo out to say there was this big complaint of harassment in the workplace and here's what we did and here's how we disciplined the person is not the way to go. That's not what I think transparency is. I think transparency is letting the workplace know that the process is in place, that it's being dealt with following up the conclusions with all affected parties, and then dealing with how we move the workplace forward. And that doesn't mean a pronouncement of what the results of the investigation is, and here's a copy of the report for everybody. That's not the right way to go, and I don't think legally that's a smart thing to do either. But I think what is important is to distill what's occurred, the impact on the workplace, deal with the interested parties, and figure out a way how to move forward. And that might take some counseling, right? It might take a little bit of individual meetings. It might take some group meetings. Figure out the best way to do so in the workplace. That is the kind of way I think you should do that. And that's where most employers fall down.
Any other comments from our other panelists on that? Okay.
I figured I'd be the bad guy on that one for sure, but that's okay. I'm good with it.
Thanks, Lorenzo. So just, recognizing we're at 1:12 here in Toronto, to kind of wrap up our discussion, I'm going to ask you, knowing that there might be people in the audience who are facing discrimination at work, or audience members who are professionals in diversity, equity, and inclusion. I'm going to go around and ask each of you to name one major takeaway that you hope people leave this discussion with. So maybe Laleh, we can go to you first, if that's all right.
Sure. I think I'll just reiterate something that I said at the beginning, and this is probably directed more to employers and people who work in the D&I space. And that's to meaningful work as opposed to sort of more performative, taking more performative steps. And the real work takes time. It's complex, and it's never ending. You can never sort of check the box and say, okay, you know, as with our trans accommodation policy, we've done it now, we rolled out the policy, that's it. So it's an ongoing process.
Thanks, Laleh. Next up, we'll go to El-Farouk.
One takeaway, distilled wisdom in a sentence. I don't have that. I was actually just flipping through the questions, and there's a comment about restorative justice. And for those of us who are in the legal profession, and I think when we're having this conversation, we should also be looking at this concept of restorative justice, and in terms of not punishing necessarily, because some harm is intentional and some harm is not, but it's still harm. And so the question of restorative justice and the questions of dignity, I think, become really important in the conversations that we have. What's the takeaway? Accessibility is the takeaway. Stuff has to be accessible to people and easily digestible. And I told you when we were talking earlier that I really liked the document because it was in simple English and made stuff. And I don't know whether we can ever make it fully accessible, but you know, that's also part of the ongoing conversation and the ongoing adaptation. So
yeah, I appreciate that. I mean, it's almost as if the legal system is not accessible itself. Therefore, it's difficult to translate. Yeah, it's difficult to translate that language for the rest of us. I'll pass it to you, Lorenzo, to just tie up our conversation here.
Look, I think workplaces are complicated organisms, and I encourage people to think of them that way, in the sense that they're not static, and people's attitudes change. But I encourage people to be transparent, to be open, and to be clear about what the issues are with respect to the potential harm which is being caused. I don't think there's anything good that comes from hiding anything. Now, I understand that if there are concerns about harm or retribution, I get all that. There are ways within the process, though, at work to address those things. And that's what I'm saying. I really do hope that the conversations that we're having open it up, make it more accessible, because I actually think that's better for employers. I think employers want to know these things. I think larger employers often don't know these things because of the way structures are. And I really hope that that's a dialogue rather than a complaint-driven system. I'd much rather see it that way. You know, I always kid people that lawyers are like plumbers. You know, most of the time we get called to fix the toilet. Sometimes we get called to install it. And I'd rather install it than fix it, to be honest with you. So I'd like to be proactive. Believe me, most firms don't like it when I call lawyers plumbers, but we are. And so I'd rather be proactive than the other way around. I recognize that we're going to be reactive in many cases, but I'd much rather get to a situation where the majority of complaints that I see aren't complaints, they're discussions. And that's what I'd really like to take away. I know that's going to take time, but that's what I'd like to see.
That's great. Thank you for that last comment. It also reminds me just to mention here that in the guide, we do try to be really clear and encourage people to, you know, familiarize themselves with their workplace policies and find ways for recourse through those policies. Just recognizing that to go forward with a human rights complaint, it's a lengthy process. It can be a difficult process. It can be a triggering and re-traumatizing process. And so that is, you know, step one in our guide is to make yourself familiar with what avenues are available to you in your workplace and try that first. So thank you to all of our panelists for your points of discussion. I think this has been a wonderful discussion, and I've been so happy to meet all of you and feature you here in our public panel. So thank you.
Thank you very much. It's been an absolute pleasure.
Great. Thanks, everyone. I'll pass it back to Jade then to close us out.
Thank you to our fantastic panel. That was a really amazing discussion. I saw a lot going on in the chat as well. I really appreciate balancing talking about the experiences of people having to actually make use of their rights and the intersectionality that comes with that. I know in the guide we do talk about how often cases are based on multiple protected grounds. So not just sexual orientation, gender identity, and gender expression. And I also really appreciate the discussions of being realistic and being honest, and from the employer perspective, being proactive so we don't have to look at the rights that people have and advocate for those rights, but instead create a culture that is inclusive from the beginning, where some of these challenges aren't things that people need to face. But the reality is that even employers who are intending to be inclusive sometimes make mistakes and sometimes make big ones. And so many gratitudes, El-Farouk, Laleh, Lorenzo, and for Meike for putting together this fantastic guide. So in terms of the resources, we wanted to share some resources with you. We have our upcoming events. So our next event is Matrices, Trans, Non-Binary, and Agender Digital Connect on November 16th. If you can't tell by the title, that is for trans, non-binary, and agender professionals and job seekers as a networking space. And so it's not an educational space if you're not a member of the community. However, we do have some great educational events coming up, including our national member webinar on creating space for uncomfortable conversations, which is an important piece to have on November 17th. Our French national member webinar on introduction to inclusive writing in French. Save the date for our next brain date, which will be focused on employee resource groups and connecting folks on best practices within employee resource groups. And then to close out our year for 2021, we have our member workshop on building inclusive HIV/AIDS workplaces. So we really hope to see you at those events. And if you're at an organization who isn't a partner already, please feel free to reach out to us to see how you can become a partner and access all of our programming. We also wanted to share some of the resources here. So, that's how you become a proud partner. Our events are resource guides, including the Know Your Rights guide, but also the others that we have put out, including Beyond Diversity, Hiring Across All Spectrums, and Transitioning Employers. We also provide e-learning programs at a fee, so check those out. And here are some of the resources provided by El-Farouk of his TED Talk. And I really want to read Moondragon in the Moss Garden. I don't have a child, but I want to anyway. And of course, many thanks to the Canadian Human Rights Commission, as well as the Community Justice Collective, who supported us in this work. So with that, I want to bring our event to a close today. I'm very grateful for all of you who have been with us today. Please check out the guide, and many congratulations to Meike for putting this together. It is not an easy task, regardless of whether you're a lawyer or not. It's not an easy task. So please feel free to reach out to us at info@prideatwork.ca, and we're very excited to see you at our upcoming events. And before I close, just a shout out and thank you to our captioner, Brittany from National Captioning Canada, Prue for doing all of the back-end work for technology, as well as Luis, who's been engaging you in the chat. So I hope you all have a great rest of your day, and that we move into a future that we know our rights, but we don't have to use them. Thank you all.